Assimakis Komninos, welcome to Digital Markets Research Hub. It's not the first time when I say this phrase, and it's great opportunity for me. I'm genuinely grateful for establishing this tradition, commenting on annually on the development, latest development, and most important development of European primarily competition law. But you also contributed to several other panels within the hub. So, but primarily today, our purpose is to discuss the latest development. I hope, though, that we will have a chance to reflect, maybe in passing, or maybe I ask direct questions on broader issues underpinning and informing this latest development of EU competition law. But let us start maybe with the first question, your general impressions of 2025 within this area.
Well, thank you, Olis. It's a pleasure again to do this discussion about this year's developments. I think 2025 was a year with a lot of interesting court cases, and also commission decisions. It's not like, I think 2023 was like we had so many developments, and 2024 as well, a bit less, but it's not perhaps like 2022 or 2023, but certainly we had some very consequential judgments at the Court of Justice. We saw the Commission essentially gravitating between soft enforcement, Microsoft Teams, and hard enforcement, Google Ad Tech, but at the same time being very interested in other more neglected, I would say, areas of competition law enforcement, for example, in the area of territorial supply restrictions, etc., which is a big thing, by the way, for national competition authorities. And obviously, this was the first year where we had the DMA non-compliance decisions and specification decisions. So that is very important, obviously. The more, I think, I would say, tricky part of this year was the fact that we have now a sort of EU-US kind of tension, so to say, which also focuses on antitrust and the DMA and the DSA. That's unfortunate, but it is what it is. At the same time, the global discussions that we have, the soul searching in Europe about industrial policy, resilience, which should be the center of our competition law enforcement, and so on, they're present. Obviously, Commission is revisiting, apart from the Article 102 guidelines, they're currently revisiting the merger guidelines, and this is extremely important when it comes to these issues. So I think 2025 was a transitory year, certainly. Many things happened, but it's more like it's the bridge between the past and the future. So I think what will happen in the next couple of years will also be extremely consequential in competition law.
So maybe it would make sense for us to revert to all these blocks which you have mentioned, starting perhaps with the development in unilateral conduct. We have many or several very important cases, and we also have development in terms of draft guidelines. So perhaps we could start with maybe highlighting the main cases and the main implications out of it.
Yes, for me, it was a very active year also, going to the court myself. I had two hearings. In January, it was the Google Android hearing before the ECJ, and 10 days ago, almost, it was the BEH hearing at the ECJ again. So unfortunately, in those two cases, we will know about next year, not this year. But still, we had some very important judgments. I think for me, number one development is definitely the Google Android Auto case, which was a preliminary reference from Italy. And as you may know, my view is that this is the case where the Court of Justice killed Bronner, let's say, in the new economy at least. And why do I make this distinction between new economy and old economy? Because the conditions that now apply when it comes to Bronner, the fact that you have to own the facility and the facility has to be essentially built, or the innovation has to have taken place with a view to keeping it for yourself, essentially for your own needs, that forget it when it comes to the new economy. The new economy is not like that. I mean, it's not about closed models. Even Apple, I mean, in any event now with the DMA, you don't have these closed models. So in the new economy, in digital, I mean, of course, you share your facility and your innovation, etc., with others. The real question for me was whether you can say no sometimes, and whether you can, for objective reasons, you can say yes to some, but no to others. And it seems to me that after Google Android Auto, forget about that. That's clear. I mean, indispensability is no longer available defense for dominant companies in that area. That's why I say in the new economy, this is no longer a good law. I mean, Bronner is no longer a good law. And in fact, Advocate General Medina, in her Lukoil opinion, accepted that. And she said, digital platforms, that's a different story. In the old economy, I think Bronner still applies. We'll come to that in a second when we talk about Lukoil, a judgment of only last week. But still, I think Google Android Auto is one of those cases. I'm a bit disappointed by that case, to be honest. It's a grand chamber judgment, fine. But I think, it goes a bit too far in my view. Certainly, for me, it's clear that the DMA must have played a big role in forming the minds of the judges when deciding that particular case. So now at least we have legal certainty, we have clarity that forget about Bronner when it comes to platforms. It's quite clear. When it comes to the old economy, or if you like, when it comes to physical facilities, etc., Lukoil now makes clear that Bronner applies as long as you own the facility and it has been built for your own needs. Essentially, it's not that you share the facility with others and so on, which, by the way, doesn't make so much sense in terms of Bronner, because in Bronner, the company concerned there, the dominant company, was sharing with another newspaper its distribution network. But still, Bronner applied. So essentially, the court has changed this case law in that sense. So Lukoil, where the commission, by the way, was espousing a rather extreme position that Lukoil doesn't apply when you have privatization, which I find, extremely far-reaching a proposition, and in the end the court didn't go there. But in Lukoil, we know now that as long as you have control essentially over the facility, and you have decisional autonomy, and there's no regulation, there's no imposition of contractual even duties, which mean that you need to give access to third parties. As long as you don't have that, Bronner applies. And I think it's a very good judgment in that sense. Now, certainly, Advocate General Medina there played an important role when it comes to Lukoil. So in terms of unilateral conduct, we had also, last week, we had this OSA case, a collective management judgment. What I found interesting there was that the court seems to be making a distinction between, let's say, core price conduct, essentially, the level of the royalties, the level of the price, etc., vis-a-vis other non-price conditions, the conditions essentially of the service. And that is reminiscent of all these cases like Google Shopping, Google Android Auto, etc. It's like the core of the conduct, and then the conditions, whether you give access in the first place, and then the conditions of access. Here it's about what is the level of the fees or the royalties, and then other conditions, non-price conditions. So I think it's a nice dichotomy here between the core and the conditions. And when it comes to the conditions, we should expect more and more Article 102A type of cases. It's about fairness, how fair are the conditions and so on.
And when coming back to Android judgment, I recently had a conversation with Konstantinos Stilano from University of Glasgow, and his opinion is that the court was too categorical, that there were more shades available for it in terms of being less strict. And do you also share this view that there was an opportunity to make it more nuanced and more elaborated?
Surely, I mean, yes, the court could not have gone as far as that. I mean, certainly it could have been more nuanced. I mentioned here in particular the question of what does it mean for the dominant company? Because if the dominant company has to start constructing particular interoperability bridges, so to say, for each and every third party that comes forward, that is a huge burden, right? And the court, instead of looking at that particular issue under the first stage of the analysis, which is to say, is there abuse in the first place, preferred to look at it through the objective justification, the second stage, so to say. And, the court was suggesting essentially, well, you can get paid for that, but that's not the issue. That's not the issue. It's not the issue that Google can get paid for time spent. The question is, if you have a minimal with minimal kind of clientele, third-party apps or whatever that come forward and say, oh, we would like to get a little bit of this and a little bit of that. At the end of the day, this is not essentially normal, I would say, for even for dominant companies. So I would have made it a bit more nuanced, possibly by referring to what does it mean in terms of the market presence of the app developer that comes forward? I mean, is it really how many users do they have, for example? Like a sort of kind of I wouldn't say de minimis, because de minimis, as we know, doesn't apply, but I would still have some kind of rationality, proportionality type of analysis there. I mean, but fine.
And also, the ruling has been already released, and the Italian Consiglio di Stato, they have already applied it. Can you maybe reflect whether the court has selected from the request the elements which are most suitable, most topical perhaps for the agenda, or that was kind of routine situation and the answer was correctly applied? What is the kind of links between the two?
You mean the Italian court?
The Italian court, after one submitting reference, the Court of Justice did it take it as it was, or somehow restructured it a little bit, maybe for some purposes, and returned it back to the Italian court, and what was the consequences?
Well, the Italian court, in my view, had leeways to examine certain things where the ECJ did not go. For example, the question of is there effect on competition, which is a substantial effect on competition here. I think the Court of Justice simply said that indispensability is not needed here, right? But I mean, the issue of what does the third-party app developer in this particular case represent in terms of demand in the market, how many end users, et cetera, these are very important questions which the court in Italy could have dealt with, but the court decided was quite. I think the Italian court was quite impressed by the strength of the core, let's say, findings of the Court of Justice, and didn't really go to certain other aspects which were not in the core findings of the ECJ, but still they were there. And question of whether there is an effect on competition, which is a substantial one. The question also of objective justification here, and so on. I mean, these were issues that could have been dealt with by the Italian court, but the Italian court didn't go there. I mean, as you know, with the Italian Council of State, no offense, but sometimes you have a bit unexpected results. I mean, when it comes to ECJ references that go back to them, in Servizio Elettrico Nazionale, Enel lost before the ECJ, but won on when it went back to the Italian Council of State. And in Unilever Italia, a case where it's clear that Unilever won before the ECJ, when it went back to the Council of State, it lost for some reason before the Council of State. So it's a bit, accidents happen when it comes to Italy.
And well, staying in Italy, the Autorità di Garante della Concorrenza e del Mercato, they just recently started investigation and imposed interim measures. And in fact, and the Commission picked up this case as well. We primarily look at cases delivered by the Court of Justice, but as we already geographically there, any preliminary reflection on this case, or maybe
Well, this is, I mean, first of all, Italy definitely is a disruptor, as I said recently in another post. I mean, in Europe, they open many cases. They're doing things, right? I mean, I don't always agree with the substance, but, they're doing things. They're quite active. Now, in this particular case, they open this investigation, but at the same time, then the European Commission opens an investigation, and the European Commission does something which I find extremely disappointing, is carving out Italy, right? I mean, so, I represented Amazon in the carve-out case 2-3 years ago when it comes to the buy box investigation. And there, the Court of Justice, unfortunately, said that, yes, carve-outs are possible. So I'm not saying that there is anything illegal here, unlawful, but from a policy perspective, I mean, these are types of conduct that are pan-European, essentially. When the European Commission opens an investigation, it is expected that this competence that it is given by Regulation 1/2003, and I refer here to Article 11, Paragraph 6, essentially, that this competence is respected and it is not relinquished. Now, it's extremely disappointing, I find, that the Commission carved Italy out in this case. I thought that after the Amazon carve-out, we would never see again carve-outs, but, there you go again. So, I
so
don't...
you have two cases instead of one, yeah, basically.
You have exactly two cases. There are some differences when it comes to the scope. There are some differences, but the core is the same. And one is for 26 member states plus EEA, or I mean, I haven't seen the opening decision, but I guess it's plus the EEA. And the other is Italy. Why is that? This makes no sense. Anyway, that's my personal view on this particular matter.
Okay, so when we talk about 102, it's hard to not to mention or the development with guidelines.
Yes, the guidelines, my views on the guidelines. We are waiting now to see the final guidelines. I think the Commission is waiting for the Google Android judgment to be out, and then they will issue the guidelines. Although personally, I don't think that the Google Android judgment is so critical. I mean, there's one particular point there as to whether tying is presumptively lawful or unlawful, sorry. But, I don't think that it's such a major case so as to delay the guidance. Still, my understanding is that they are waiting for that and perhaps another or two judgments. Let me put it this way. I hope that there were, my hope is that the guidelines would be revisited quite substantially. And we would have back concepts such as anti-competitive foreclosure, the focus on consumer harm, explanation what is consumer harm. Note what I'm saying. I'm not talking about consumer welfare, in that sense. The court's case law is quite clear about consumer welfare. It is an ultimate objective if you want, but we have all these other objectives which are proxies essentially for consumer welfare. So I'm not talking about that, but what I'm talking about is you need to explain why you prosecute conduct. And what is the reason? The reason is consumer harm. And what do we mean by consumer harm? And that is what I would have expected. This is quite well explained, I thought, in the guidance paper. Now, when it comes to presumptions and that, my view is that the case law does not allow for presumptions, but at the end of the day, it's not so presumption is not the most critical thing when it comes to the guidelines, because presumptions at the end of the day, all these presumptions, if they get introduced, they will be quite weak presumptions because of the case law. Immediately the dominant companies will come forward with evidence, and that's it. Essentially, then the commission will have to disprove the evidence put forward by the dominant companies. So at the end of the day, I don't think presumptions will change much. What is important for me, where the core is anti-competitive foreclosure and the two conditions that now the commission has introduced, which is conduct going against competition on the merits and anti-competitive effects or likelihood of effects. So these two conditions, especially the first condition, in my view, they cannot really be operationalized, if you like. These are general, if you like, programmatic conditions mentioned by the Court of Justice, usually in the early paragraphs of judgments before we go to the legal test. The court refers to conduct going against competition on the merits, blah, blah, blah. You know, you have that, but this is just programmatic. I mean, it's nothing really, this cannot be operationalized. This cannot be a global legal test. You need something more concrete. What is conduct going against competition on the merits? You look at what they have in the guidelines, for example, and there they are mentioning conduct, which afterwards the Court of Justice said that, no, this was not conduct that was going against competition on the merits, for example. So, you know, already what we had in the draft guidelines, the list that they had with examples of conduct going against competition on the merits was not a good one, actually. It was disproved by the Court of Justice later on. And, you know, this is extremely, I would say, unhelpful in terms of being very theoretical and very nebulous. So that duality of the two conditions I don't like, I have to say. For the legal tests, you know, fine. The Commission could have explained why they want a particular legal test to be a bit, let's say, more attuned to problems that they may have in proving conduct, as long as they're intellectually honest and they say, well, that's what the Court of Justice has said, but we believe that there are valid reasons for this or that particular conduct to be treated slightly differently in this or that way because of A, B, C, D. You know, of course, I have no problem with all of that. You know, this is in the Commission's prerogatives at the end of the day. And if the Commission were to follow such an approach, I'm sure the courts would find it persuasive.
But speaking of presumptions, what practically, can you just visualize to us the scenario A and scenario B, if the presumptions will be too proactively applied or more conservatively and considerately? What would be the implications in the development of future investigations and cases?
There will be no particular major implication in my view. Why? Because that's why I think the whole idea about presumptions and discussion is not necessarily you know, very rewarding, so to say. Why? Because you see, I mean, let's say that in the Commission's decision, what you will see is you will have this first paragraph which says this conduct, for example, exclusivity type of conduct, is presumptively abusive, presumptively restrictive, let's say. Abusive, I wouldn't say, because then you have the objective justification, second stage. But let's say it's presumptively abusive, right? That would be fine to have like as a paragraph, but you know, in all cases before the European Commission, you will have the dominant company coming forward with specific arguments of economic nature and legal nature, but mostly economic nature, to disprove that presumption. So essentially, that presumption will be useful, let's say, for this programmatic paragraph up there. I mean, at the first part of the legal section in the court, in the Commission's decision, but then immediately afterwards, the Commission will say, nevertheless, the dominant company put forward the following evidence, right? And then they start going through the evidence, And if the evidence is not particularly persuasive, then the Commission will make its own case and say why that particular evidence, for example, has mistakes when it comes to certain calculations, or why that particular evidence is not conclusive because other more qualitative, for example, evidence should be considered, and this is the more qualitative evidence, and so on. So at the end of the day, what do the presumptions give us? Nothing. Just this programmatic paragraph up there, just to, for the legal service, pardon, to feel happy and say, oh, they are presumptively unlawful, but, then we have to consider everything, right? Honestly, I cannot, and I have many times thought about that, I cannot find an instance where the presumptions would have any particular practical significance and implication.
This year, you have also published a very voluminous and very appealing, judging by the cover and by the content table of contents book, together with Ekaterina Ruseva. You co-edited a very impressive volume, Article 102, Past, Present, and Future. Can you please tell us, outline to us the key output? It's hard to do because everybody is different, etc. But maybe there are some common themes and maybe some patterns you could share with us.
Well, indeed, I mean, this is based on our Global Competition Law Center conference, which we had last year in Bruges. That was about Article 102. This volume is extremely useful for those that study Article 102 because essentially you have, indeed, as the title suggests, you have the views about the past. So you have extremely interesting contributions on the past of Article 102, how it all started, I mean, what the drafters of the treaty, what the early judgments had in mind, and so on, which is very good to know. You always have to study history before you design the future approach. Then the present, obviously, there are articles which refer quite a lot to the draft guidelines of the European Commission. And you also have extremely important and interesting contributions on what we should have in the future, essentially, what we should be doing with regard to Article 102. I don't want to mention particular contributions, but let me say that all schools of thoughts are represented. We have Commission officials which wrote actually the draft guidelines. We have also Commission former officials which wrote the guidance paper. We have academics, obviously. We have practitioners who have pleaded those cases, who have dealt with such cases before the Commission. So I think it's a well received volume at a critical time as we are now waiting to see the final guidelines from the European Commission. You talk about this last year and in some of your papers as well, but maybe for those who are watching now, particularly for students, the impact of guidelines, how binding the provisions of the guidelines are, how much leverage the Commission does still have in terms of deliberating which aspects, which elements of it should be refined, and how much they can fine-tune. What is at stake in terms of the future enforcement of 102? And maybe a sub-question: if the guidelines are binding primarily for the enforcer themselves, whether issuing guidelines on DMA is such a prudent strategically idea. But maybe we can discuss this sub question in the part related to the DMA. Yes. First of all, there are guidelines and guidelines when it comes to competition law. For example, you have guidelines such as the horizontal guidelines or the vertical guidelines. Or technology transfer guidelines, essentially. There, in reality, the Commission is putting down its own policy and explains why certain agreements should be dealt with in this or the other way, etc. Those guidelines are not like these draft guidelines. Like, I mean, in the sense that those guidelines are not there to kind of, you know, to codify the case law. No, I think this is the Commission's approach, and essentially those guidelines have been extremely influential with the Court of Justice when it comes to Article 101. There is no doubt about that. These guidelines, these draft guidelines that we have here, are different in the sense that, you know, they purport to codify the case law, essentially. They are very legal also. This is a very legal document, unlike the guidance paper, which is really based on economics and was trying to translate a bit economics into law. This is purely a legal document. And the codification is there, definitely, but at the end of the day, what we want from the Commission is not just the codification. I mean, you have good academics which codify the case law. You have good books which are doing that. But at the end of the day, what I would have expected is what you, European Commission, believe the guiding force behind Article 1 should be, essentially. Now, that particular element, which was very present in the guidance paper, and that's why the guidance paper was particularly persuasive after the first accidents, let's say, at the Court of Justice, but later on became extremely persuasive. It's because it was something new, and it was something intellectually at a high level, essentially, of a high quality also. It was something new, very qualitative, and therefore it became persuasive. Now, if the Commission wanted to depart from the guidance paper, there were ways to stay at such a high level, retain the qualitative features, essentially, and tell us more about what is, at the end of the day, behind Article 102. And, you know, maybe we could have, maybe the Commission wanted to give more emphasis on you know, the Article 102A, for example, right, which it never touches now in the draft guidelines. Maybe could explain a bit more about those things, right? Instead, what we have is just a codification of the case law, a codification which I might say is not always very, I would say, to the point when it comes to the case law. It is a bit selective at times, right? And in that sense, how can this be persuasive in the same way like the guidance paper was persuasive with the EU courts? The EU judges and the referendars and those people there, they know very well what the case law is about, right? So in that sense, I don't think it will be persuasive so much, at least with the EU courts. Now, with the NCAs, definitely, the NCAs will read it as the Bible, for sure. Companies, here, you know, I think there's a bifurcation, if you like. There's two parallel roads. So one criteria, if a dominant company comes to me and asks about compliance, if the criterion is, do you want to have trouble with the European Commission? Then I will follow the guidelines. If the criterion is, on the other hand, what is really legal or illegal, and can I, if I decide to go before the Court of Justice, what can I win and what will I lose? Then I think these guidelines, let's see, of course, what the final product will be, but these guidelines will not be very helpful. If that is the criterion there, I would just read what the court is saying in its case law.
Two short questions. The guidance paper has been amended. So I wonder, do you think the amendments which have been introduced were sufficient for the purposes which you have somehow suggest, or your intuition was thinking about the Commission's intentions or the good governance? And the second question, you said when the dominant company comes to you talking about compliance, an empirical question. Do dominant companies usually know that they are dominant, or it comes as a big surprise to them from your observations and communication with clients?
Let me start from the last one. I think companies usually are aware that they have market power. Now, whether they are technically dominant or not, that's a different question. But usually our clients would say, we dispute that we are dominant, but at the same time, we have to be careful here. And let's take as an assumption that we are dominant. What then how should we deal with certain types of conduct, right? So I don't think that's a major issue at the end of the day. Now, of course, it's true that sometimes you have dominance in ridiculous markets. If the market is defined in a ridiculous way, you can always find dominance, right? It's not at the end of the day the showstopper, whereas whether there is an abuse, that's where the core is, I would say. The guidance paper has been revisited. Yes, it was minimally revisited by the Commission. I think it was a kind of stopgap type of intervention in order to wait for the new guidelines. No, I think judging from what the Commission really has in mind, no, that was a bit of a hermaphrodite type of product essentially now, because you have the broad principles of the guidance paper are still there, but then the Commission has intervened in many respects and has really, it doesn't make much sense, let's say, as a whole. I think the Commission could have produced something in the guidelines, which would be certainly explaining a bit more about what is at the end of the day that is at stake here. I think the anti-competitive foreclosure principle, I wouldn't have changed it. There's pro-competitive foreclosure and anti-competitive foreclosure. This is very fundamental. The Court of Justice case law accepts that and so on. The notion of consumer harm, perhaps the Commission could have explained a bit more to explain, for example, what it means in terms of quality, what it means in terms of choice. Consumer harm is not just price, right? But it loss of quality, loss of choice, loss of innovation, and so on. I think the Commission could have done that. And still such a product would be quite influential. Anyway, let's see what the final product is. I mean, it's not prudent, let's say, to always criticize. Let's see what the final product is. But if I had a magic one, for me, the most important thing is, let's say the Commission abandons the presumptions, but keeps everything else. Would I be happy? No. Presumptions are not the core. The core is anti-competitive foreclosure and why we are intervening in one or two cases, and definitely this idea of the two conditions, including competition on the merits, I think that makes no sense.
And thus we will have an opportunity to discuss it revised in 2026, I hope. Let us move to the effectiveness of enforcement cases.
Yeah, I mean, there we had a few cases on the enforcement, on the effectiveness, let's say, of enforcement in the effectiveness of enforcement area. We had some public enforcement cases, such as, for example, the Caronte judgment for Italy. This is about the deadlines, internal deadlines that the law sometimes imposes on national competition authorities. The court there was very mindful of effectiveness. So I don't think that the court was particularly happy with these deadlines when it comes to public enforcement. But most of the cases had to do with private enforcement. We had Nissan, for example, where the court took a rather far-reaching approach when it comes to time limits for follow-on claims. And now, essentially, for the time limit to start counting, you have to wait for the final judicial review judgment at the national level. This is not the case in the EU level. So there is a certain divergence there, but it shows you how important for the Court of Justice is private enforcement. That's why I said, when this case came out, I said private enforcement in steroids, right? And then, as you say, the Stichting case, this is the Dutch case. It's a Brussels regulation case, but I think what lies behind is this idea of effectiveness of private enforcement. Essentially, there, the court is opening the gate for many cases to be heard in the Netherlands, so that's clear, or in other jurisdictions which are quite friendly to claimants. but also very importantly, it allows for claimants, in particular, in case of representative claims, certainly, to go in a particular court, and then you don't need to go to other local courts in that same member state, essentially. And I understand from experts in the area of Brussels regulation that this was not necessarily what was expected in this particular case. Indeed, the Advocate General's opinion was not going there. So the court has departed from the AG opinion. But generally, you know very well that the court is extremely sensitive when it comes to private enforcement. The direct effect of Articles 101 and 102 must always be safeguarded. I would stop here when it comes to effectiveness cases. I think these are the most interesting developments.
You mentioned the proxy word steroids, which very elegantly leads us to the next category of cases, sport cases, where we have already experienced several phases of evolution and very thorny relationship between EU law and sport, or the supposed autonomy of sport and professional sport, with all the caveats, etc. Remember the white paper on sport and its cultural DNA of each nation, particularly football, depending on the preferences. Now we witness very significant evolution of this line of reasoning. Please remind us.
Exactly. This is the area which was where the Court of Justice was most active when it comes to competition law, sports. Who would tell that, right, a few years ago? And by the way, a couple of weeks ago, we had the anniversary of Bosman, 30 years. So certainly, this is an area where a lot is happening in Luxembourg and also in Brussels. After digital, I would say it's sports these days when it comes to stuff happening. I think we could start from Lassana Diarra, the case involving the footballer Lassana Diarra. Unfortunately, because of the anonymization of the Court of Justice, it's known as the BZ case. I hate anonymization, unfortunately. That's interesting because we had, for the first time, references also to no-poach agreements by the Court of Justice, so I find that interesting. Then we had the trilogy of opinions by Advocate General Emiliou. I particularly liked the Tondela opinion. I mean, this is about the no-poach agreements again. As a matter of principle, the Advocate General agrees that this would be by object infringement, but in this particular case, he thinks because of the specific circumstances, COVID in Portugal, etc., he believed that the Portuguese Competition Authority was wrong to categorize that particular agreement as a by object infringement. But for me, Oles, the most important development was Sereng. And this is because this touches upon my other area of expertise, which I like a lot, which is arbitration. Now, this case was about sports arbitration, but essentially the court wanted to deliver a judgment that would be more a judgment of principle, essentially. And if you read the first part of the judgment, essentially it covers also any kind of arbitration, except, of course, for investor-state arbitration, where we know where the court's mind is. So it does cover commercial arbitration. And the practical result of that judgment, in my view, is that public policy control by national courts is a very important tool. And that particular control is sufficient, essentially, to deal with the issues that arise. But I think that now the court is telling us also that this type of public policy control by national courts has to be meaningful. It does not go as far as a total revisiting of the merits of the arbitral award, but it has to be meaningful. Ideas about a minimalistic control, etc., I think now are put to the shelves, essentially, after this judgment. So it's a very interesting judgment. And there's also another Spanish preliminary reference on the question of commercial arbitration and competition that is pending. So perhaps we will know a bit more when the court decides that case as well. But certainly sports is the hottest area after digital these days.
After digital. So let us move to digital and to the sui generis competition law, digital competition law, as you have coined the term, and now it's being used more and more commonly. We all are mindful about the kind of juristic DNA of the DMA, but the rationale of it is competition.
Of course.
What do you make out of the first non-compliance decisions? The selection of cases, are they the easiest, the most obvious instances of alleged non-compliance? Are they being somehow tailored? Do we have to look at the cases separately or cumulatively? Please reflect.
Well, we had two non-compliance decisions, the one against Meta and the one against Apple. These raise totally different issues, essentially, but still they show that the Commission certainly prioritizes a bit as to which case they will go ahead with a non-compliance decision, where they will engage a bit more in terms of regulatory dialogue, where they think that the regulatory dialogue cannot really lead anywhere, and they need essentially to make their views to put their views on paper and kind of possibly test them before the courts, right? I mean, I thought that the Meta decision is very interesting. I mean, how they interpret Article 5.2. We have seen now that possibly there is also the other chapter, by the way. This is the chapter of compliance with the decision, and this is extremely very important chapter in this case. And we see now that possibly there may be some kind of settlement there. It seems that there is a common understanding. At least I'm not involved, at least from what we see in the public domain. Apple is about the anti-steering provisions of the DMA. It's about Article 5.4. Very interesting questions as well there. I'm sure the EU courts will have a lot to say. I'm sure they are very eager to hear those cases themselves. Then we have specification decisions as well, not to forget. Everything will go to the EU courts, that's clear. I don't want to say too much here because this is a very sensitive area. But what I keep out of this, I think, is what I've just said before, which is it's very interesting to see how the Commission prioritizes its non-compliance cases vis-a-vis the, let's say, more dialogue-prone cases, so to say. And I think that makes sense. That makes sense because not everything is the same. Not every gatekeeper is the same. Not all types of conduct are the same. For example, Apple's model is a bit different than Google's model when it comes to 5.4 and so on. So, let's see what the EU courts will say. What I have also seen, however, is that, and this is not criticism to the European Commission, but it's just an objective feeling that sometimes they're a bit maximalist in the way they read these provisions. And I think they expect the EU courts at the end of the day to tell them and to tell us what the position should be. I don't think the Commission reads some of these provisions as I would have expected in an ex ante type of tool. I think they're reading them sometimes as they're reading as if they were Article 102, sort of general clause, and certainly being a bit maximalist there. But, I mean, maybe it's just the first year, maybe this is normal, this is natural, and we will need certainly to see what the EU courts will do. The EU courts will have a very important role to play, also with annulments sometimes, if we see that the Commission's decision has gone too far.
There was a case where in the Commission words, in course of the regulatory dialogue, the Commission has closed investigation of alleged non-compliance, and you have commented on this as well. What is jurisdiction's value or specificity of this procedural step?
What I find extremely interesting here is that we have a decision. And that's very important because these decisions, which is not the case necessarily in antitrust. In antitrust, in the old days, you had this one line saying the Commission has closed proceedings in case AT, blah, 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 right? So here we have a decision, and this has a reasoning, etc. And therefore, that can also be very useful in terms of private enforcement in the DMA, because national courts, in my view, are also bound not only by non-compliance decisions, but also by these types of decisions, right? When they say, this is how we should be interpreting the provision, this is how we have viewed the measures at stake taken by the gatekeeper, and therefore we believe that there is nothing to do here, no further steps are necessary, etc. This is something that definitely national judges should see.
So
In
basically, it's
antitrust,
carrot.
unfortunately, we didn't have that. Sorry, I was saying that in antitrust, we didn't have, unless you had a rejection of complaint, extremely rare, etc. You didn't have, let's say, positive, so to say, decisions. And as you know, the Commission has never taken an Article 10 decision in antitrust.
Okay, so I wanted to pick up your mind as academic, as thinker, not as an actor now. I am in charge of I have a very powerful toolbox with Articles 5, 7 and others in the DMA. And there are two modalities, two extremes as a DMA team. One can be just, pro forma complying with the obligations, first come, first served. They allow the representative of business users shout or singing, or the more convincing their songs of the sirens are, the more I'm seeing the compliance through of this specific obligation as the mission of the DMA. Bearing in mind that my toolbox of bullets is limited, because every shoot generates criticism, etc. There is also another kind of trajectory of enforcing the DMA where you are somehow doing it for some purposes. Using DMA, using obligations not as the end in itself, but as a means to achieving something, to achieving this contestability and fairness. First of all, where would you, among these two polarities, where would you put the prudent or the correct enforcement philosophy for the DMA and similar tool in the UK? And secondly, can you enforce it without having some broader goal in mind?
I mean, yes, I mean, the two goals of the DMA, as we know, are fairness and contestability, right? But that, I mean, those, or less, unfortunately, these are just words at the end of the day. Fairness, contestability. How can these very general terms inform very specific obligations? So I'm not particularly, I'm not particularly, let's say, persuaded that these two concepts should have any major role to play, in the sense that when you have ex ante regulation, that's a totally different tool than having general clauses, essentially, which you apply ex post. In the ex ante regulation, I think that's the idea of having ex ante regulation, the companies must know to the maximum extent possible what it is that they need to do and what it is that they have to avoid, what is prohibited, essentially. And where do you find that? Well, you find that in the letter of the law. So, I mean, this is essentially about complying with the letter and the spirit of the law. I'm not leaving the spirit out, but the law. So you need to go to this specific obligation. These are not general clauses. This is a major difference between the DMA and antitrust. In antitrust, we have general clauses, abuse of a dominant position. Then you have case law, which explains, and so on and so on. That's not what this tool is about. This is about the 21, I don't know how many they are, obligations, which are very specific and they are ex ante. So, in my view, to answer to your question, I think that the criterion should be compliance with the letter and the spirit of these specific provisions. Now, Outcomes is something else. Outcomes is for the legislator. I mean, the legislator can look at outcomes and can decide in 5 years' time, I don't know, whether something else needs to be done, or maybe they need to change this or that in the DMA. But outcomes are not for the enforcer. The enforcer there is not to give specific outcomes in the market. So I feel very strongly about that. And in other words, this is an obligation in itself to comply with the specific text and the spirit that lies behind the text. There is no obligation of a specific outcome in the market. That's not what the DMA is about.
The point is taken. Do you want to say maybe a few words about the DMCCA, or is it something which is too early to judge yet?
It's too early, I think, to talk about. I think it's a bit more flexible a tool than the DMA. It's a bit more flexible, I think. But we'll have to see how it plays out. And I'm not I'm not involved in such cases in the UK. But certainly we look to them with a lot of interest. Let's see. I mean, we have had some designations or the equivalent, let's say. Let's see now what happens when the real process starts, so to say.
I'm mindful of time. There was a development about legal professional privilege, and also development in the relationship between competition and industrial policy. I wonder if you could reflect on both, or maybe pick the one which is most suitable, because basically you have reflected the position on industrial policy in answering the question about the DMA.
Yes, indeed. So on legal professional privilege, I would just say that we just had a policy brief by the European Commission, which we read. We were not impressed in the sense that, first of all, this was about the in-house counsel privilege, right? I don't want to go into the merits of in-house counsel privilege. In any event, we would be talking only the lege ferenda, not the lege lata, because the European Court of Justice's case law is very clear. So legal professional privilege goes only to external counsel in the EEA. Now, in the EEA, let's see, because we have had some other developments, but certainly external counsel only. Now, the question is, should the Commission propose in the new regulation a rule that would be going against that case law? I mean, I think there's nothing standing in the way for the Commission doing that, legally speaking, because it would be new legislation. I don't want to go into that, but what I found especially disappointing is that this policy brief said essentially nothing. We just had a footnote about the second legal basis of LPP, because LPP has two legal bases. One is, of course, protection during the due process essentially related cases, etc. But now there's privacy of communications, essentially. This is now the second legal basis. This is pursuant to the Flemish bar case of, I think it was December 2023, maybe. I can't remember, either 2022 or 2023. A very important and consequential judgment, which essentially tells us now that it's not just about due process, but it's also about protection of privacy, which means that, for example, LPP now has to be respected, legally speaking, also in merger control cases, right? I mean, the Commission was always respecting LPP de facto, let's say, in merger cases, even before, my understanding is. But we never really had a procedure there in terms of enforcement, quasi-criminal enforcement, and so on. So you could have said that, well, we just giving you something en plus, but it's not that we are bound to give you that. But now it's clear that whenever you have advice of lawyers, that is protected. And therefore, I found the the downgrading, if you like, of this second legal basis a bit disappointing. I mean, when it comes to the member states, I pointed to some errors there because I don't think that it's as clear-cut as the Commission suggests. But anyway, let's not spend too much time on that. This was just about a policy brief of the European Commission. On industrial policy, I mean, I've already talked about that. It's a broader, much more important discussion. I don't envy the Commission these days. They have to revisit their guidelines. They have to do it very quickly. I'm talking about the merger guidelines and all that. So I would say, generally speaking, that we should not depart too much from the core of competition law. And the core of competition law is protecting markets, protecting consumer welfare in the broader possible sense, and certainly, you know, I mean, it's not the job, I think, of competition authorities to create this or that champion and so on. I mean, I'm a bit more nuanced there vis-a-vis other practitioners, I would say. I have my own views on that particular issue. We have to be a bit careful there. Because,
okay, that's your normative position. But in terms of capacity, do you think if such job does exist, are they capable? Do they know how to facilitate and support European champions? Or it's even if the normative prescription is there, it's still impossible to do because it's a different toolbox, requires different skills, etc.
Well, I think the Commission has in the past dealt with even technical issues quite well. I mean, they have the capacity to go into these types of analysis, to be honest. I'm more, you know, for me, the question is, once you get there, once you go there, then you are in a very tricky area. And you will say, but again, that's normative, but it's normative, but it's also very practical. The question is, are you really independent to go there? I mean, you're an independent competition authority. You draw your if you want, legitimacy from being a technocratic authority which does certain things. The moment you start going into everything that moves, essentially shooting at everything that moves, then I think that you are losing a bit of your independence when you do that. This is government policy at the end of the day. Most of the problems that we have as Europe are not due to the competition law, right? The competition laws that we have, they're not due to merger control. Now, to be fair, what I would expect from the Commission is to be a bit more open when it comes to efficiencies, taking efficiencies into account. I know that they are taking efficiencies into account, but I want to see it in the decision. I want them to clear mergers on the basis of efficiencies without remedies. I don't see that. I know that they are taking them into account, but it's a black box. It's behind the scenes. I want to see decisions where mergers have been cleared purely on the basis of efficiencies. That, yes, but to rock the ship entirely, I wouldn't do that.
2026, what will be preoccupying your mind in the first months of 2026?
Currently, as you know, we have an unfortunate tension between the EU and the US. This is definitely going to be present as well in 2026. I hope good reason prevails and we don't have any accidents there. Sometimes the debate is quite personalized and focuses on particular companies and so on. I find that extremely unfortunate. So that is a major, certainly, concern. Then, obviously, the revisiting of the merger guidelines, that's another battleground. You know, I hope we do have a Director General as soon as possible at the DG Comp. I think it has happened for the first time, at least in my own kind of knowledge, that we cannot have a Director General for some reason, which is unclear to me. So I would plead for a bit more of normality, let's say, in competition law enforcement, because out there sometimes I have the feeling that there's a crazy world. So a bit more normality would not be bad.
And can you maybe give us a flavor of the importance, of course, such a pivotal role of Director General at DigiComp is very important, but maybe personality, how important is it just to have it finally confirmed, uh, appointed, or it's a political question about who will be chairing the DG?
My sense is that currently it's just politics, essentially internal politics within the commission and power politics, because obviously the DG is a very important person in the commission when it comes to competition law, the GComp in particular. You have the digital cases, you have also all the other the merger cases and so on. I think it's part of it. What I find disappointing is in terms of optics and symbolisms. Why can't we have a director general here? Is it politics? Well, we thought that competition law was not about politics. I mean, competition is always about politics, right? But there is a limit to all that. So this is, I think, representative of a broader kind of problem that I see more and more: politicization. And this is not good, what's going on currently with this delay. I mean, it took ages to have a new chief economist. So now ages again to have a new DG. So this all leads to concerns about politicization, and I don't like that. Now, the position as such is important. Of course, I would say over the last few years, the positions of the deputy director generals are also extremely strong. I mean, very powerful positions within DigiComp. And the current acting director general, certainly one thing you cannot accuse her of is of not being strong. I think it's a very strong lady that is in charge. But still, there's symbolism here. And we need to fill that gap as soon as possible, I think.
You mentioned politicization, and I refer those curious people to one of your interviews, which you have given in podcast to an Indian podcast, can't remember the name, where you have developed a kind of taxonomy of different types of good and bad and neutral politicization of antitrust.
I have
So we'll
forgotten
be
about my
discussing.
taxonomy. Unfortunately, I have forgotten about my taxonomy.
Well, I refer yourself then first. We have to finish with recommendation. We never mentioned AI during the conversation, but we finish, which is an achievement, with recommendation to students who are very perplexed these days and have many challenges and opportunities. How would you recommend what to do and what not to do?
I speak now with also having in mind that my son has certainly recently started to show an interest in competition law. So, it seems that this area is always quite attractive to young generations, essentially, of lawyers. Look, competition law is always very interesting because it is in the borders of law, politics, and economics. I find it extremely difficult to identify another area of law which is so interesting, like competition law is. Now, of course, competition law has been changing over the years. It's becoming, first of all, in terms of the case law, to know all the cases, it's really unmanageable sometimes, right? I mean, I remember when I was studying it in the early 90s, you knew more or less which the cases were. Perhaps in cartels, you had lots of them, but, you could navigate through them. But in the other areas, not so many. Whereas now, there's so much technicality, there's so many judgments, etc. But still, it's so interesting. So interesting. I mean, which other area of law you see cases where you have frontline articles in the Financial Times and elsewhere? And, I think also we competition lawyers, and I mean we academics and practitioners, are quite a fun group, I would have to say. Sometimes we have our debates, and sometimes there are conflicts. Of course, most of these conflicts are really nonsensical, essentially. As Kissinger used to say, academic debates are the stronger ones because of the stakes being so low, right? So you have that feeling, but we're a very nice group of people. I mean, we have our own group, which is quite an open one. I don't think it's a closed group, let's say. Certainly not as closed as the arbitration group, I mean, which I see sometimes. So I definitely encourage young students to dedicate themselves to this area. It never ceases to be interesting.
Assimakis, Komninos, thank you very much for sharing your excellent ideas with us.
Thank you, Alice.